Exactly right. Rules Committee, come to order, and thank you very much for joining us this afternoon. We're delighted to have Louise Slaughter back. Louise, we missed you.
I'm so glad, because honestly, I missed you all so much that I brought you pies. So
You did bring some pies.
I did bring pies.
Now, did we
and-
drink coffee with them, or what did we?
No, I'm counting on you for that, Pete.
Yeah, but I mean, do we drink coffee with the pie?
Of course.
Okay.
If that is your inclination.
That's
But
generally,
I'm
I've got
really
one, I've
glad
got
to
a
be
young
back.
preacher here in the crowd from Raleigh, Texas, in the district, so
Well-
I don't do the otherwise.
I do want to say that I'm really sad about Mr. Newhouse.
Yes.
He's one of the nicest people in the House of Representatives and one of the nicest men I've ever known. And having lost my own husband not too far back, I can certainly empathize with him and look forward to having him back too. But I want him to know we're thinking about him.
You know, in fact, as my colleagues are aware, Congressman Dan Newhouse this last Friday evening lost his wife to a battle for cancer.
37 years.
And a wife of 37 years. And when I went out to visit them last year, Carol was in the battle, knew she was in the battle, and had an attitude about it that was pretty good outlook. And Dan has been gone for a couple weeks, also came back for a week. And we missed you, and now we miss Dan, so we do respect and pray for that.
Indeed.
That life that
Yes,
comes there.
indeed. It's hard.
Yeah. Thank you very much. Well, it's Police Week here at the Rules Committee, and each May, we have an opportunity in Congress to thank the men and women of law enforcement, local, state, federal law enforcement, men and women who have raised their hand to accept responsibility not only for defending the Constitution, but the right for all of us to live safely in our own homes. They're men and women that walk into dangerous circumstances. They respond to the sound of the crack of a weapon and to the cry of a baby, and to help when it happens. And so I'm proud for them to know that today we're going to consider H.R. 115, the Thin Blue Line Act, and H.R. 1039, the Probation Officer Protection Act of 2017. Just this last Friday, I had an opportunity a tremendous opportunity to participate in a ride-along in Richardson, Texas, with some of the finest men and women in uniform from the Richardson Police Department in Texas. And I must say, it served as a stark reminder to me as we chose an evening to do it. And it's a stark reminder of how much these officers sacrifice. They put their life on the line. They put their partners on the line every day just to keep our communities safe. And I'm humbled really by this opportunity to see that as we move into this legislation this week at the Rules Committee, I think it's something that we can respond to the men and women in blue and say we're trying to do a little bit more to help you. Under current federal law, probation officers may arrest a probationer or an individual if the officer has probable cause to believe the individual has violated the terms of his or her probation. However, probation officers do not possess the authority to arrest or restrain a third-party individual if he or she attempts to carry out physical harm against the officer or to prevent the officer from their official duties. So actually, we're helping based upon feedback that has really we've been aware of for some time, but that we're going to approach in law today. Our H.R. 1039 updates the Federal Criminal Code to protect probation officers and give them the tools which they're asking for that are necessary really to complete their missions rather than having to wait for backup or for someone else, perhaps a more difficult circumstance. This legislation amends the Federal Criminal Code to authorize probation officers to arrest hostile third-party people without a warrant if there's probable cause to believe the third party forcibly assaulted or obstructed a probation officer engaged in the performance of their official duties. This is what I think is common sense legislation being asked for. I also had the opportunity this morning to meet with Officer officers from the Dallas Police Department. Once again, some of our finest and well-trained officers in the country. You'll remember this was the law enforcement agency who last July was faced with a deadly shooter. We had 5 Dallas police officers who, when they could not determine where the shooting was coming from, gathered together, walked down the middle of the street to draw fire to themselves because there were hundreds of people in sight of this killer. You also know that this department's been through a lot this year in trying to recover from the death of those officers, their families, and although they have maintained what I believe is professionalism, encouraging each other in the performance of their duties, commitment to protecting people of Dallas, they are still in mourning and suffering. So we know that protecting our city is also hard, and I want to thank the Dallas Police Department, as I did this morning, for their continued protection of themselves and the people who they represent. Second bill under consideration is the Thin Blue Line Act, which amends the federal criminal code to include the killing or attempting killing of a law enforcement officer or first responder or as an aggregated factor in the federal death penalty determination. This will be interesting. I did not know this. This legislation will send a message to those who target police officers, firefighters, or first responders with violence can be met with a harsh penalty. It acts as a strong deterrent to violent crime and benefits the men and women who serve to protect our communities. So I think that both of these bills are strong reminders about not only how dangerous the job is, but how important the men and women are who are trying to enforce the laws that protect us. So during Police Week, I think we're responding accordingly. And I appreciate our men and women of law enforcement. As you know, my father served in law enforcement for a number of years, and I feel a strong kindred spirit to those people and what they're trying to accomplish. So, welcome back.
Thank you, thank you. Let me say, too, the Dallas Police Department acquitted itself so extremely well. I'm glued to the set and watching that, and I came away with the impression you had one of the best police chiefs in the world.
David Brown.
I've never seen anything like him, and he, if we had hundreds of David Browns, it was incredible. The strategy, everything that they did, intending to take over the streets and really protect the people of Dallas, I'll never forget it. And when we did the ACA, I had somebody call to threaten to take me down at 50 yards, and my grandchildren. And the FBI and 2 town police departments watched my grandchildren get off and on school bus for about a month and a half. My office in Niagara Falls was broken into and windows broken. So, but my grandchildren never knew a thing about it.
Yeah.
Never saw a thing about it. And since Bob died, the police department in Fairport takes special care of me, and it's so wonderful. They even came one day and offered to shovel out my driveway because the guy hadn't come to do it, but I knew that was way under too much for them. So we have a great relationship, and I think all of us do on our side as well. We're not crazy about these bills. They came up without any committee work or anything else and much to do. I'm sure Mr. Cicilline will talk about that. But we certainly understand it, and we know who keeps us safe every single day. And we know who stands out in the rain and the sleet and the snow and the hail to make sure that we are okay. We never forget that. And we want the absolute very best for them. So we would like to do bills that would really do that. Frankly, I'd like to pay them more. How about that?
Well, in fact, communities are struggling doing that and to take care of them. And as you know, that's why.
But we could not survive without them, and I think we need to recognize that. I yield back.
Thank you very much. By the way, I don't know if you had a chance today, but we went in around 2 o'clock today, and there was a young man who was the preacher who gave the prayer today, and he's sitting right over there. You might recognize him, the Reverend Bruce Hargrave.
Yes.
And he's got his young bride there to his right, and Kathy, and their good friend, Arnett Dyke, who is from Rowlett, Texas.
All right.
And Rowlett, Texas is a suburb of Garland, Texas, which is a suburb of Dallas, Texas. And we're a suburb of Fort Worth, Texas.
We're always glad when people come to the Rules Committee because most people feel it's like watching paint dry. But we're happy up here.
Well,
We
Bruce
do-
is
we
a
do
city
the
council
right work.
member in Rowlett, Texas also, so we get to call him
Well,
honorable back home.
Right.
So I
I'm
just-
sure he's honorable up here,
I
too.
just want you to know that he offered a prayer for all of us today,
Okay.
and we appreciate it. So we're delighted that the gentleman is here. So we have the gentleman also who's from north of Rowlett, Texas, who is here. And John, I'm delighted that you're here, and David. And without objection, anything you have in writing, we'll go ahead and enter that in the record. David, do you know whether you're taking, I should consider you Sheila Jackson Lee today? Are you giving testimony, or are you here only for an amendment?
I'm here for my amendments, but I believe that there might be some confusion on that.
Okay, well, as we get to it, I don't want to have John and then not include that. So if you want to speak up at that time, you do. Otherwise, if you'll just notify us that you're talking about the amendment. Thank you very much, gentleman from Texas is recognized, Mr. Ratcliffe.
Thank the gentleman. Chairman Sessions, Ranking Member Slaughter, members of the committee, thank you for the opportunity to appear before you today to consider the rules for H.R. 115, the Thin Blue Line Act, and H.R. 1039, the Probation Officer Protection Act of 2017. Both of these important pieces of legislation provide the men and women of law enforcement who serve and protect our communities every day with the support that they so richly deserve. This is, as the chairman said, a particularly important week this week. It's National Police Week here in the United States, and it's the time that we take to reflect on the sacrifices that those make that run towards danger and march into harm's way, and we need to do everything we can to support them. H.R. 115 amends federal law to add the killing of a state or local law enforcement officer as an aggravating factor for a jury to determine during the sentencing phase of a trial when the jury is considering whether a sentence of death is justified. Current law provides a list of 16 aggravating factors a jury is required to consider when deciding whether a death sentence is warranted in any particular case. Among those include whether the defendant acted in an especially heinous, cruel, or depraved manner, whether a defendant engaged in substantial planning or premeditation, whether the victim was particularly vulnerable, or whether the victim was a high public official. Presently, a high public official, for purpose of the statute, includes a number of prominent public individuals, including but not limited to the president, foreign head of state, a federal judge or federal law enforcement officer. However, current law only contains the specific protections for federal officers, not for state or local officers. So H.R. 115 remedies this situation by including the killing or the attempted killing of a law enforcement officer as an aggravating factor in a capital murder case. Similarly, H.R. 1039 closes a loophole in the law to ensure that federal probation officers are able to perform their duties safely and effectively. Under current law, a federal probation officer may arrest a probationer or an offender on supervised release if the officer has probable cause to believe that the offender has violated a condition of his or her probation or release. The officer may make the arrest with or without a warrant. Unfortunately, current law does not grant probation officers arrest authority in situations where a third party, like a spouse or the child, attempts to physically obstruct an officer or to inflict physical harm on an officer. Despite the fact that interfering with a probation officer in the performance of his or her official duties is in and of itself a crime, federal probation officers lack the authority right now to restrain a physically interfering third party. In fact, a probation officer's only course of action at this time is to retreat from the situation. That not only exposes the officers to a heightened risk of harm, as they're not permitted to subdue an assailant, it also allows the probationer to conceal or destroy evidence that he or she has violated the terms of his or her probation or supervised release, or committed any other criminal activity. Let me be very clear. This bill would not give federal probation officers general arrest authority. Rather, as noted, it grants them very limited authority to arrest a third party who is interfering with the duties of the officer. As the chairman said, I believe these are common sense proposals that are needed to protect the men and women of law enforcement. I respectfully request that this committee adopt the appropriate rules for consideration of these bills. I very much appreciate the opportunity to testify, and I'm pleased to answer any questions.
John, thank you very much. By the way, congratulations to your daughter, who I found out this weekend is going to go to Texas A&M in College Station, Texas. She was an intern in my office a summer ago, and congratulations to her, please.
Well, I thank you. Very much appreciate that. We were hoping that she'd go to college, but she decided to go to Texas A&M. If you were from the University of Texas, you'd really appreciate that.
You know what? Let the record reflect the gentleman spoke the words and he was under duress. That way he can later find a way to get out of the problem he's got. Mr. Cicilline, we're delighted that you're here. Is the gentleman speaking about the bills or an amendment that the gentleman might have?
If it's okay with the chairman, I'd like to begin with the amendments, and then if Ms. Jackson-Lee is not here, I will.
The gentleman is recognized to speak on the purpose of an amendment.
Thank you, Mr. Chairman. It's great to be back before you and the members of this committee, and I'm asking that you make 3 amendments in order. Let me say at the outset, the killing of a law enforcement officer or a first responder in the line of duty is always a tragedy, and of course, I strongly support efforts to ensure these cases are dealt with justly and swiftly. And I can tell you in my service as mayor of the city of Providence, the most difficult day that I ever had was when we lost Detective Sergeant Jimmy Allen, who was murdered, a Providence police officer in the Providence police station. And so I recognize the gravity of the loss of a police officer. But I also strongly believe that every defendant should have the assistance of a competent lawyer and have available the benefit of evidence-based forensic science. I know my colleagues would agree with me that when dealing with issues related to the death penalty, it's especially when dealing with legislation that extends the opportunities for seeking capital punishment, that we must proceed with great caution while legislating. And that's why I've introduced 3 amendments. The first amendment would establish a commission to recommend to the Justice Department standards for the use of forensic science in capital crime cases. The use of forensic science to analyze physical crime evidence is a vital part of our criminal justice system, and we should continue to invest time and resources in the advancement of the forensic science field. The National Commission on Forensic Science, which expired on April 23, 2017, was established to work in partnership with the National Institute of Standards and Technology by the Department of Justice. It was tasked with the great responsibility of enhancing the practice and improving the reliability of forensic science. In a statement released by the Department of Justice on April 12, 2017, announcing the expiration of the National Commission of Forensic Science, it states that, and I quote, "The more effective a forensic system we have, the better equipped we are to solve crimes, more swiftly absolving the innocent and bringing the guilty to justice." End quote. I strongly agree with this statement, and that is why my amendment would require the Attorney General to establish and submit a report to Congress on the activities of the Commission. The National Commission of Forensic Science made significant contributions, including providing a unique forum for a wide variety of stakeholders to participate in the important conversations surrounding improving forensic science. This amendment will ensure the continued improvement of our forensic science abilities and eliminate the concerns of a similar commission expiring. My second amendment would direct the Attorney General to submit recommendations to Congress on guidelines for the appointment and performance of defense counsel in death penalty cases. The quality of defense counsel in a death penalty case is imperative to ensuring a reliable determination of guilt and a just outcome. Representing a defendant in a capital crime case presents unique complexities and challenges at each stage. Defense counsel must not only have a mastery over this complex area of law, but must also stay up to date on relevant developments in the areas of forensic science and psychology. In 2003, the American Bar Association formally adopted guidelines for the appointment and performance of defense counsel in capital cases. My amendment would address this issue and help jurisdictions improve the qualifications and training of their defense counsel in death penalty cases. My final amendment would authorize funds for additional resources for defense counsel in capital cases. Modern capital cases are impacted by constantly changing, highly nuanced legal principles and scientific developments. In order to meet these demands while still maintaining a high threshold of competency among defense counsel, we must appropriate the necessary funds and resources for the appointment of defense counsel in death penalty cases. Capital cases are among the most financially burdensome, as these cases are extremely time-consuming and demand extensive preparation. Additionally, most defendants cannot afford a lawyer and must rely on an appointed attorney to provide them with representation, even though few states are able to provide enough funds to compensate lawyers to thoroughly investigate and litigate a case. Therefore, even though an effective attorney can mean the difference between life and death, capital defendants may be frequently represented by overworked and undercompensated lawyers that cannot meet the rigors of working on such a complex case. This amendment will help to ensure that all defendants are provided the high-level defense counsel they deserve in a death penalty case. And so I ask my colleagues respectfully to make these 3 amendments in order.
Thank you very much. Does the gentleman wish to offer additional testimony?
Yes, Mr. Chairman, I'd like
Gentleman's
now.
recognized for the purpose of speaking about the 2 bills that are placed before the committee.
Thank you, Mr. Chairman, and I would ask unanimous consent to submit both of these in writing, and I'll just give you the highlights. On behalf of Ranking Member Sheila Jackson-Lee, I offer a testimony in opposition to H.R. 115, the Thin Blue Line Act of 2017. Of course, we acknowledge and commend our law enforcement officers for the service to our country and the services to our communities, and of course, like everyone, are deeply saddened anytime there's a loss of life, particularly for those engaged in the performance of their duties. But this bill does not answer this quest for justice because it is duplicative, constitutionally problematic, and counterproductive. There was no hearing in the legislation, which sets a very troublesome precedent in the Judiciary Committee. This legislation is unnecessary and is really a misguided attempt to politicize the unfortunate deaths of law enforcement officers and could ultimately exacerbate existing tensions between law enforcement and the communities they serve. First, H.R. 115 is duplicative of existing laws that punish by death. It does really not make any additions to the existing law, but in fact adds, as a result of an amendment that was offered in the committee, the death penalty as a possible imposition for those who might, quote, target law enforcement officers. There was no definition of what targeting means, and so one could be fearful that people who are protesting law enforcement or protesting a particular officer might in fact be guilty of targeting. There's no definition in the statute, and so that raises very serious constitutional questions. Secondly, the bill, as I mentioned, makes the killing of a law enforcement officer or a first responder punishable by death as an aggravating factor, but it does nothing to provide any additional requirements for that. In addition to federal law, all 50 states currently have laws that address the killing of a law enforcement officer, firefighters, and first responders. The aggravated factors in this legislation serve a narrowing function, which is to determine which type of defendants are eligible for the death penalty. The bill defines death penalty eligibility based solely on the status of the victim. There are substantial concerns about that. And as I mentioned, the vague language, including targeting law enforcement officers, could also sweep and subject to the death penalty innocent lives who are merely exercising their First Amendment rights to speak about the mounting abuse faced and witnessed in their communities. And so that raises a very serious constitutional question. There's also substantial evidence about the disproportionate impact of the death penalty based on race and a number of well-documented reports and studies that have evidenced gross racial disparities in the use of the death penalty, and therefore that also should be considered by this committee. There is a number of studies that are referenced in Ms. Sheila Jackson-Lee's written testimony that support those assertions, and I offer them to the committee for their consideration. In addition, I offer testimony in opposition to H.R. 1039, the Probation Officer Protection Act of 2017. This bill would provide probation officers with the ability to arrest third parties without a warrant. So this would be an authorization to arrest individuals without a warrant by someone who is not a trained police officer. The first problem with this legislation is the bill would violate the separation of powers. A federal probation officer is an extension of the court and serves in its administrative capacity as a court liaison in the monitoring, supervising, and arresting a probationer who has violated the terms of his or her probation. Probation officers are employees of the judicial branch and have a close relationship with the courts that they serve, and hence the idea that you would give to them executive functions, that is enforcement of the law, which is clearly an executive function, presents a very serious separation of powers problem. And in addition to that, you would put courts in the unfair position of having to administer justice, and their employee would be a witness in the proceeding, which presents serious concerns about abuse of power with respect to that determination. A second issue is the constitutionality. The Fourth Amendment, of course, prohibits police officers from detaining persons absent probable cause or prior approval by a judge or magistrate. And despite that clear requirement in the Constitution, this bill seeks to arm probation officers with the same authority without the threshold for the finding of probable cause or warrant. And it would really also endanger the lives of police officers, of probation officers who have not, unlike police officers who receive months of training on de-escalation and arrest and findings of probable cause. That is not what probation officers receive. They receive about 6 weeks of training having nothing to do with arresting people. And so you're really endangering the lives of police officers by creating a situation in which they would be expected to act like a police officer. There was no evidence presented in written letters to the committee that a probation officer had ever sought the assistance of a police officer in such a situation, and the police either failed to respond or declined to respond or didn't show up in time to provide the assistance. So this is a problem in search of a solution in search of a problem. There just is no evidence that that probation officers need this. There is no evidence that police officers have not responded promptly to these situations, and it invites, frankly, many more problems than it will solve. And for all of those reasons and the further reasons outlined in the testimony of Sheila Jackson Lee, she offers her testimony in opposition to H.R. 1039.
Ms. Celine, thank you very much, not only for your presentation of your ideas, but also for representing the gentlewoman from Texas. We appreciate you very much. Mr. Ratliff, I'm from Dallas, Texas. I think I know what targeting is. I looked at it last July. A deranged man took a rifle and shot 5 police officers intentionally. He targeted them, he knew who they were, and he did it intentionally. I hear these terms regularly because people are targeting, once again, that term. They are taking police officers and intentionally picking them out. So targeting and intentionally picking somebody out, I don't know the legal definition, but I will tell you, I think I know it when I see it. I'm delighted that you have chosen those terms because it's not by accident. They intended to do it, they sought them out, and they did it, and I'm delighted that you're doing this, and thank you very much. I appreciate your not only insistence as a former U.S. Attorney for the Eastern District of Texas, your familiarity with law enforcement, but the things that are challenges that are placed against them simply because they're police officers is targeting. It's unfair. It's not the right thing to do in the performance of their duty. And I would feel the same way and did when we had a member of Congress who was targeted and shot, and those people around her also. And I feel very strongly about this issue. People cannot, should not do that without the repercussions, and I appreciate you very much. Chairman Cole.
Thank you very much, Mr. Chairman. I want to thank the gentleman from Texas for bringing the legislation, which I certainly intend to support should it come out of this committee, and I expect it will. And I was going to pretty much leave it at that until he made his remark about Texas A&M. Now, for the record, I'm a very proud Oklahoma Sooner. You bet. But my son did go to graduate school due to the generosity of Texas A&M down there. And just, again, for the record, when he called and told me how excited he was that he'd gotten this research fellowship at Texas A&M University, of course, I congratulated him. I was proud of him. But I said, you know, son, this does mean you'll be an Aggie. And he said, I know, Dad, but they hate the University of Texas just as much as we do. So and that rivalry, I actually went down and saw actually a great game between A&M and Texas. A&M fortunately won and actually put us in the national title game in 2008 as a result. But anytime I could be surrounded by 80,000 people dressed in something that looks like red, hollering, beat the hell out of Texas, it was just a wonderful place to be. So I thought since there wasn't an Aggie up here, somebody had to speak on their behalf. Yield back.
Does the gentleman wish to defend himself?
Yes, Mr. Chairman. In my defense, I would submit for those that aren't familiar, telling Aggie jokes is as much of a Texas tradition as the Alamo, so it's expected. Even Aggies tell them.
need to, the committee is aware that the gentlewoman from Texas has arrived. The gentleman needs to know that the presentation has been made by Cicelyne. Mr. Cicelyne has done that, and I wanted the gentlewoman to be aware of that. Gentlewoman from New York, the ranking member.
Yes, and I thank Mr. Cicilline for standing in until Ms. Lee got here. I appreciate your remarks as well. As I said at the outset, all of us are extremely grateful to the people who face danger every day on our behalf. But we think these bills could have been made better constructed and maybe had some more input into them because, as David points out, there are instances where it could be even more dangerous for police if these laws are passed. So while we probably will not be supporting these, we are there at the ready anytime to do what we can for our first responders.
Yes, ma'am. Delighted that you're back, Louise.
Oh, thank you. I'm
missed
so
you.
glad to be back. I feel like I'm home. Isn't that crazy?
You are. And you see yourself up here.
Yeah,
It's a
I
great mirror,
hadn't
isn't it?
noticed it, yeah.
Yeah, there you go. Gentlewoman yields back her time. Is there any Republican that would seek time? The gentleman from Louisville, Texas, Dr. Michael Burgess.
Thank you, Mr. Chairman. I want to thank our witnesses. I don't have specific questions, but you reminded me, Chairman, in your remarks of that day, the 7th of July of last year, when the city of Dallas was shaken to its core by those murders, when our police officers were ambushed in downtown Dallas. And Chairman, it was at your direction that members of Congress met with Chief Brown, Chief of Police, several days afterwards. And I felt so bad at the time. This poor man hadn't slept, I don't think, in days. But he took the time to meet with us and answer all of our questions and make certain that all of the concerns of the congressional delegation in the area make sure those concerns were addressed. So, Chairman, I just wanted to acknowledge that and thank you for setting that meeting up. It will always stand out as one of the sad, but really the high marks of my time in Congress. I thank you for that.
Yes, sir. Thank you very much. By the way, as a result of that meeting, we, within a short number of days, passed a bill at David Brown, who's the chief of police for Dallas. He asked for two things, and one of them is law, and one is we're working on it. But he said there's no training that's available for local law enforcement on an active shooter basis. And it was developed and begun, and police departments around the country are now developing systematic understanding of how you look at, how you target, how you protect, how you defend, how you do these things with an active shooter. And that is one of the things that, as Dr. Burgess speaks about, that our chief came right out and said, look, we need it. And we passed that bill, gave it some proper funding, and it's my understanding it's available now.
He's extraordinary.
He is,
I think we should learn from him.
yeah, well, he is a dear man, Gentleman from Massachusetts.
I have no questions. I just hope that the amendments that Mr. Cicilline and others offered will be made in order. I yield back.
Thank you very much. Judge?
Same from me. I'm hopeful that we will make those amendments in order, Mr. Chairman. And I wish to express my concern that we continue to have meetings here and present legislation that doesn't have hearings. At some point, we're going to really have to get back to regular order. Otherwise, we're making ourselves in a position where stuff just appears here without there having been any input from either side. And that's not right.
Yes, sir, and thank you very much. The gentleman has noted this a number of times, and I've not only understood that, but I agree with the gentleman very much. Thank you very much. The gentleman from Colorado. The gentleman does not seek additional time. By the way, Mr. Buck, we're delighted that you're with us today. Does the gentleman seek time? Gentleman's recognized.
Thank you, Mr. Chairman. Mr. Cicilline, you mentioned that there's a separation of powers issue with the HR 1039. Are you aware that the Supreme Court has a police force?
Yes,
And are you aware that they make arrests?
Yes.
And are you aware that the defendants in those cases that are arrested go before federal courts?
Yes.
Do you consider that a separation of powers issue?
Yes.
Do you also aware that probation officers make findings of violations against probationers and testify in federal court in front of the very judges who are supervising those probation
And that
cases?
derives from the supervisory responsibility of the probationer over the parolee or probationer. They don't have that same supervisory responsibility over a third party. So you, as a result of being on probation, surrender to the jurisdiction of the court, and therefore it's appropriate that an extension of the court, the probation officer, provide that supervision. It is quite different to allow the probation officer to arrest a third party who is not under the supervision of the court.
So what you're saying is it's quite different for a probation officer to walk into federal court and to swear out a warrant, have a judge sign it, and then testify in that federal court in front of that judge. There is no conflict there. There's only a
Correct, 'cause
conflict.
that person is already under the supervision of the court as a condition of his or her probation.
I understand that, but you're saying that a member of the judicial branch should not testify in a judicial proceeding, or there would be a
That
conflict.
proceeding of that individual is already under the supervision of the federal court. That is quite different than a third party who is not under the supervision of the court, who has not consented to supervision by the court, who hasn't signed conditions of probation, who's just a citizen of the United States, who's arrested without a warrant by someone who's not a trained police officer, who then testifies. In
So
court.
somehow,
Those are very different
a judge,
circumstances.
in a judge's mind, he can separate out a
Yes.
conflict between those two situations.
Of course.
Okay.
Judges do that all
I
the
have no
time.
further questions.
Thank you very much. Gentlewoman from Wyoming.
Thank you very much, Mr. Chairman. I don't have any questions. I just want to associate myself with the comments of my colleagues. Thank you very much for bringing this legislation. It's absolutely fitting this week that we honor the sacrifice of particularly our state and local law enforcement officials. My grandmother, my mother's mother, Edna Vincent, was the first female deputy sheriff in Casper, Wyoming, and in the 1950s served on an otherwise all-male force. And so I'm very grateful that we're taking this opportunity to make sure that we protect our state and local officials as well. Thank you, Mr. Chairman. I yield back.
Thank you very much. We appreciate the gentlewoman and her comments. Is there any other questions for this panel? Thank you very much. I want to thank both of you for taking time to be here. As always, David, you bring a little bit of a spark to this thing. And I know how that is. John, good luck with the calls back at the office. Good luck with that. Does the gentlewoman seek time to explain her amendment? The gentlewoman is recognized. Thank you very much. Just so the gentleman is aware, the gentleman, Mr. Cicilline, waited till the end of his amendment process and then spoke 4 or 5 minutes, including reading your testimony that you had provided, and that was accepted into the testimony. And if the gentlewoman has displeasure with that, that would be directed at me because I allowed him to do that with my decision I made. And I'm sorry if the gentlewoman's not happy. Gentlewoman's
Chairman, I don't have any displeasure. I'm in the minority, so I can't make any impact on this
Well,
hearing.
the-
So I have no displeasure. I just want to make sure I can put my statement in the record, ask unanimous consent.
Without objection.
I thank you. And Plains.
I don't want to let him take all the burden on that, Sheila, because we had heard you were coming from the airport, and we were about finished. So we on amendments.
We thought we were honoring your
Yes.
words and
When
the spirit of
Cicilline
what you were
read
doing,
them.
and but I could have had him not deliver, but I chose to do it thinking it was the right thing. And I appreciate the gentlewoman giving me that consideration and the consideration of the gentlewoman from New York. Thank you very much. Yes, ma'am.
Thank you very much, Mr. Chairman. Let it be very clear, I have no angst in this issue. I'm moving
Yes,
forward
ma'am.
on my
Yes,
amendments.
ma'am.
I can't control airplanes, and I thank the committee for
Absolutely.
its
Yes, ma'am.
kindness. I have an amendment to H.R. 1039, the Probation Officer Protection Act of 2017. This amendment specifically requests that the study include, that this is a comprehensive study amendment, of the new authority granted to probation officers and the impact of this authority on third parties. My amendment would request and is limited to any instance of an abuse of power in the exercise of such arrest authority, any complaints filed about exercise of such arrest authority, and any harm resulting from the exercise of such arrest authority, including any civil action alleging the violation of a civil right in the exercise of such arrest authority. This is my amendment for H.R. 1039, the Probation Officer Protection Act of 2017. My amendment to H.R. 15115, Thin Blue Line Act of 2017. This amendment requests that the Attorney General make grants to study and implement effective management, training, recruiting, hiring, and oversight standards and programs that will promote appropriate use of lethal, non-lethal de-escalation techniques by law enforcement officers. Let me, first of all, acknowledge that this is Police Week and that all of us honor our officers. As I walked into the building, I acknowledge our Capitol Police and thank them for their service. All the past week, I was interacting with police officers in my district. Tomorrow, we'll be holding a hearing, and my chief of the City of Houston Police Department will be present, and we honor them. I believe these amendments will help to enhance the rights of both law enforcement and civilians and make these bills responsive to our constitutional concerns and as well to our concerns on our officers. So I ask the Rules Committee to consider them to make them in order.
Thank you very much. Without objection, anything the gentleman brought in writing under this will be into the record also.
Thank you.
Is there any member that would seek time with the gentleman from
I just want to
Massachusetts?
say we support the gentlelady's amendments and hope they'll be made in order. I yield back.
Thank you very much, Judge. Judge would wish that his vision also be the same, and the gentleman from Colorado also. Is there any other member of the committee that would seek time? Thank you very much. I want to
Thank you very
thank you
much,
for
Mr.
taking
Chairman.
time to come join us today.
Thank you.
Is there any other member?
Apologize for my tardiness.
Yes, ma'am. Well, we did not hold that against you at all, and we're delighted that gentlewoman took time. Is there any other member that would seek time to discuss H.R. 115 or H.R. 1039? Seeing none, this now closes the hearing portion, and the chairman will now be in receipt of a motion from the gentleman from Oklahoma.
Mr. Chairman, I move the committee grant H.R. 115, the Thin Blue Line Act, a closed rule. Rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-17 shall be considered and adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. Finally, the rule provides one motion to recommit with or without instruction.
You've now heard the motion from the gentleman from Oklahoma. Is there an amendment or discussion to that?
Yes, Mr. Chairman.
Gentleman's recognized.
On the H.R. 1039, the Probation Officers Protection Act, there are 4 amendments submitted here. One from Congresswoman Demings from Florida states that the director of the FBI may be removed only for inefficiency, neglect of duty, or malfeasance in office. From Congressman Kennedy from Massachusetts reinstates the authority to appoint an independent counsel for investigation of the forced resignation of Michael Flynn, National Security Advisor by the President, and I'm abbreviating these. By Congressman Liu of California reinstates the authority to appoint an independent counsel, very much like Mr. Kennedy's, and Mr. Moulton of Massachusetts reinstates the authority. So there are these 3 amendments. We know that you're not going to do this. It's going to be a closed rule. We understand that. But I do want it on the record that these amendments were put into these bills as a kind of a desperation move so that we can get some kind of conversation or something going on what we're going to do here about what's going on at the White House. So I'd like to ask if you would make these in order and give them the appropriate waivers and let us vote for them. Does anybody else on this side say anything? Okay. Thank you.
Thank you very much. In fact, as the gentlewoman suggests, there were a number of amendments. They were presented late, which does not present me any problem, but each of these that were presented, in fact, are not germane. They deal with areas that are outside of this Probation Officer Protection Act of 2017. And my suggestion to the committee is that we're not opening up that side of the discussion, especially without a hearing that the gentleman has talked about, which is so essential.
Well, I wish you had hearings on the things we're voting on.
Well, I think there was a
Every now and
markup.
then I'd like to bring something
Yes,
up
ma'am.
here we'd like to have
I
some
agree.
attention on
I
in the
agree
House of
with that.
Representatives, as well as 78% of the American people are
Well,
asking for an independent investigation on what the heck is
Well,
going on.
you know what, that might.
I know you well enough to know you want to know too.
In fact, I do have a strong sense about me that I believe
And it
that,
should be heard.
I think that there are a number of issues that need to be vetted further and would be part, but probably not in this context. But I appreciate the gentlewoman and the members who have brought this up, knowing that several of them, at least one of them, came from a former law enforcement official who would have a deep and abiding faith in that.
And a former soldier. Terribly
And a
important.
former soldier from Massachusetts, no doubt.
And the grandson of a slain president.
And the grandson of a slain president, a gentleman.
That should get a little attention.
Well,
shouldn't
it got my
Those
attention.
three?
I know all
I mean,
three of those
Moulton
people.
is a great hero.
He's a fine young man.
Yeah.
Okay, further discussion, further
I
discussion.
would like to have it considered. I'm sorry I did.
Gentlewoman, no, she's
Okay.
respectfully asked, and I get that. My point is that none of these were germane. Okay, so somebody wants to tell me now, we were doing HR 115
Right,
instead of
I did the wrong
1139. So, look,
It's my fault.
why don't we ask this question one more time, which I should have done because I just let the gentlewoman
It was
speak
okay.
most respectfully. Is there amendment or discussion on HR 115?
And that is the
Thin
probation.
blue line. I'm sorry, I did not note that myself. We've got two rules that are here.
No, not on this one.
Okay. Seeing no discussion, the vote now be on the motion from the gentleman from Oklahoma, HR 115. Those in favor signify by saying aye. Aye. Those opposed, no.
No,
The ayes have it, the ayes have it. Accordingly, the gentleman representing law enforcement, as he's done his career, the gentleman from Colorado, former district attorney, the gentleman, Mr. Buck, will be handling this for Republicans.
okay. Oh, and I think Hastings for Democrats?
And Judge Hastings will be handling this for Democrats. Thank you very much. Chair will now be interested in a motion from the gentleman from Oklahoma, H.R. 1039.
Mr. Chairman, I move the committee grant H.R. 1039, the Probation Officer Protection Act 2017, a structured rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member, Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule makes an order only the amendment printed in the Rules Committee report, if offered by the member designated in the report, which shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in the bill. Finally, the rule provides one motion to recommit with or without obstructions.
You have a motion from the gentleman from Oklahoma. Is there amendment or discussion?
I have an amendment at the desk, Mr. Chair.
Thank you very
I move
much.
the committee make an order and give necessary waivers for the following amendments to H.R. 1039. Numbers 2 by Representative Kennedy, 3 by Representative Demings, 5 by Representative Liu, and 6 by Representative Moulton.
Thank you very much. Consistent with the discussion that would be had earlier, we will recognize not only your ideas in support of those, but also the underlying premise behind them. We appreciate that very much. Further discussion? Seeing none, the vote now be on slaughter amendment. Those in favor signify by saying aye. Aye. Those opposed, no.
Roll call, please.
Noes have it. Gentlemen, will poll the committee for the process of determining roll call vote.
Mr. Cole? No. Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Mr. Buck? No. Mr. Buck, no. Ms. Cheney? Ms. Cheney, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern? Aye. Mr. McGovern, aye. Mr. Hastings? Aye. Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk will report the total.
4 yeas, 8 nays.
The amendment's not agreed to. Further amendment or discussion. Seeing none, the vote now be on the motion from the gentleman at Oklahoma. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it, the ayes have it. And accordingly, the gentleman from Georgia, Mr. Collins, will be handling this for Republicans.
Mr. Polis of Colorado.
And Mr. Polis from Colorado will be handling this for Democrats. I know there's going to be a question asked, and the answer is, at this time, I do not have anything for us for the rest of the week, and so I do not anticipate we would be having another meeting. Thank you very much, Louise. Welcome back.
Welcome. And I
Thank you
want to
very much.
invite everybody in for Sugar Bar Pie.
So we've got cake.